Court officer?
वो लोग कुछ आवाज आएगी तो आएगा ना।
Visible copies of arrests is not fine.
I appear in the first matter. Seems to be a small copy 194. It's a part of a report. I would not file a better copy. There's only one part of the report. The main contention, my lord, is that the Deputy Commissioner, Revenue Deputy Commissioner, has no jurisdiction.
All right. Shall we 1 week time?
Please,
How much?
if your lordship should consider appropriate, my lord.
Actually, your voice is not clear.
The revenue operation, they are in a force because of some third-party interference. The Revenue Deputy Commissioner issuing the notices.
Pollution control board, direct notice, standing council, or next time.
You can ask for that. Is there any council for pollution control board?
They are there.
Yeah, Mr. Go Joshi, I think appears, my lord.
Mahesh Chaudhary.
Mahesh Chaudhary.
Mahesh.
You may accept notice.
I will accept.
You may accept notice.
Should be for respondents 2 and 3.
One
State
government.
1, 4, and 6 by AJ and
4, 5.
1, 4.
1, 4, 5.
4 and 5, my lord, I made the officers personally a party because they have alleged malafidis.
We are giving notice to the councils who are present right now.
Please, please.
Accept notice for 1, 4, and 5. No, not 4, 1 and 6. You accept notice for 2 and 3. Seek instruction list next week. In the meantime, the petitioner may make good the office objection.
Please.
Copy may be served. Copy may be served.
Yes,
Copy-
please.
Copies they will serve. You
Serve today.
A copy of the writ petition may be served during course of the day.
Please.
Serial number 2, Milad.
Yes.
Milad, I appear for the petition, Milad. Milad, the constitutional validity of the rules, Milad. The rule, one particular rule, Milad, clause B of rule of this Karnataka, Milad, prevention of illegal mining transportation rules is challenged on 3 grounds, Milad. 1, section 9 regulates the levy of royalty charges. The state government has no jurisdiction. Number 2, Milad, Rule 63A, Rule 63B of Mineral Concession Rule 1960. And then, Milad, the Rule 39 of the 2016 rules, Milad, governs the levy of royalty charges. And third ground is, Milad, Section 23C does not authorize the state government to levy difference of royalty charges. Milad, there is no jurisdiction. On those 3 grounds, Milad, we have challenged this one particular rule, Milad. Milad, just I have pointed, Milad, there is another writ petition. Your lordships have already posted the matter for hearing on 18th, Milad. WP 19,773 of 2018. Your lordship posted the matter on 31st of...
Have this matter along with that.
Yes, Milad.
There is no consequential order or challenge. It is a challenge based on virus of the rules. It was passed in the year 2011. Long lapse of 11 years, it has been challenged. There is no consequential order.
Come to your prayer.
Please, Milad.
Come to your prayer. Now you, by way of certiorari, you are challenging the validity,
Yes,
of,
Milad.
rule. Validity of rule.
Yes, Milad.
Can it be done?
Yes, Milad. That is what this thing, Milad. Right, your lordships are hearing this matter, otherwise heard matter, my
I
lord.
think that by way of writ of certiorari,
19,773 of
you
2018.
can challenge the rules by way of writ of certiorari. How you say that can be done?
Right, now I have not only challenged this challenge, but right, on the ground that it is without.
Probably you are not understanding, mister. This relief cannot be granted. This by way of certiorari, you cannot get a rule challenged.
Right, I have second prayer, your lordship may kindly see writ of prohibition, prohibiting them from collecting the difference of royalty charges because it is not provided.
Very sorry to observe that you do not know the concept of the which relief can be granted by which challenge claiming the writ.
Right, I will seek
You have to seek a declaration to declare the rule ultra vires.
Grant me 3 days time, right? I'll seek declaration also.
The reliefs which you have claimed cannot be granted.
Right, I will seek a declaration, my lord. I will amend the writ petition. Seek a declaration also, my lord.
Against whom writ of prohibition can be issued?
Right, against the state, my lord. State has no jurisdiction at 23C. Your lordship may kindly see.
No, you are quite senior. You have put in so much of years in your practice. At least don't argue in this manner. You must understand.
Yes,
which writ can be prayed, what relief can be claimed. It's very
right, I will seek your lordship may grant it 3 days time, right? I will seek declaration also.
This totally writ petition deserves to be dismissed, in fact. You withdraw this and file proper petition.
Right, may I just submit, my lord? I will seek amendment, seek a declaration, my lord.
How much amendment you seek? Everything is wrong. All prayers are wrong. We can dismiss it, nothing more.
Right, may I just submit, my lord? I will seek amendment, my lord. Your lordship.
Oh, sorry, we will not allow you to improve this way.
Right, certiorari is the only remedy, my lord, against the challenge to the rule, my lord.
All right, we'll decide it then. We'll pass the order.
Right, your lordship.
Certiorari is the only remedy by which you can challenge the rules. Then we will decide this issue first.
Right, then your lordship will kindly give me some 2-3 days time, my lord. I will seek a.
Sorry, we will not give you. If you want, you may withdraw with liberty to file proper petition.
Yes, my lord. Your lordship permit me to withdraw with the liberty to seek declaration also, my lord.
Not expected from a person, counsel, senior counsel like you, that you do not know what is certiorari and what is prohibition.
Right, kindly see prayer D, my lord.
Notice for 1, 2, and 3. Accepted by Leonard AGA. The writ petition has been filed, seeking following relief.
Right, prayer D, may I seek, my lord, just your lordship kindly see, my lord. I have sought declaration also.
Please keep quiet.
Yes.
After arguing the matter at some length, the counsel for the petitioner makes a statement at the bar that he may be permitted to withdraw the writ petition as the prayer made in the writ petition are not proper. The writ petition is accordingly dismissed.
Just may I say to lordship
liberty to file afresh.
My lord, prayer D, your lordship may kindly see for a minute, my lord. I have sought for declaration also, my lord. Kindly see prayer D, my lord.
If you will insist, we will decide this. If you insist, we will decide it.
Yes.
Do you want to argue the matter?
I'll file a fresh petition, my lord.
Number 3.
Same, my lord. Both are same.
Same order. Yes, what is the matter?
Your Honor, I'm Partington, number 1. Number 2 is last Monday I suffered some health problems like a vertigo I had. I'm able to walk and talk properly today. So I'm thinking whether I should, the matter is about BBMP. A number of issues have been raised. and number of prayers have been asked for. I think that this is a good PIL. It will give good results if the court will give me time to proceed with this. But if the court feels I cannot do a good job, either you can appoint an amicus curiae for me, or I'll withdraw, because I'm not feeling very well today.
We can give you time. You come again.
Yeah.
We'll postpone the.
I think prayers will not maintain. It's
What
not
is the-
properly. That's
Yeah,
page
hi,
14.
what is the matter?
Because he's seeking, prayers are such a vague that he is asking prayer to repair the BBMP Act. That's such a mandamus. Assuming that it is a mandamus also. And not to conduct elections to the BBMP, negative prayers.
I'm saying that unless the atmosphere
I think
is very
some
correct,
better legally equipped person is required to assist.
unless the atmosphere is
These prayers cannot be considered, I think.
unless the environment atmosphere is correct. I'm not saying don't conduct it. And I'm saying that BBMP Act is not well written, and BBMP Act is not implementable. And there will be many problems in implementing this unjust.
Have you earlier approached the court, filed any petition earlier?
No.
Then you are not aware what all is required for filing a writ PIL. The prayer has to be made in a very specific and proper manner.
Should it take help from any amicus curiae?
Yes, therefore, it would be better that if you want to file a petition, proper petition, then you will have to file it, withdrawing it, and thereafter file fresh. Yes, taking some help from some person who has the legal knowledge of your cause may be good, but the thing is the petition should be maintainable.
You have children, is it? Because you see the cost title, occupation, father of new BBMP and new world.
I believe that BBMP is not.
No, BBMP is your son.
BBMP is father of.
And what is this new world?
New world means whatever is applicable for BBMP can be extended to India and to the whole world. I'm very clear about what needs to be done.
Right.
Unfortunately, the court does not believe in this, so I withdraw.
That's what I asked.
Yeah.
Prayer. He's asking to appoint himself as a mayor.
No, you are not supposed to argue with him. You whatever you have to say, you have to tell the court.
See, he is telling you wrong things. He is saying that I am asking for it to be made.
Not necessarily whatever he says that we accept.
Your Honor, I want to say one thing and I'll get out of it. Because many times I've seen in courtrooms where the advocates will come and say wrong things which are false. No, there's no recording of these false. He's saying which is not true. So who is to help me?
Direct.
He's telling you something which is not true. I said interim way, not me. That too only up to adjudication. There's nothing wrong in asking for it. I'm very well qualified person to be an interim mayor. I'm better than any mayor that has ever been. There's nothing wrong with here. I've done a good job, to the best of my ability.
No, what is your grievance?
My grievance is number of grievances. Number one grievance is against each respondent. I can give you very briefly about respondent number one, the state of Karnataka. See, the political parties are doing lots of violations of law all over the place, and they don't collect any evidence, and there's no evidence of what they do at the micro level. That's number one. Number two, R2, which is State Election Commission. They are allowing people who are not persons. They're not nowhere is it defined in the law as to who are these persons who are being nominated for elections. Because in RPA 951, Any person will be nominated. Who are these persons? What is a person? And how do you define person? Number two. Number three is regarding Chief Commissioner of BBMP. I believe the BBMP Commissioner is not able to, has not implemented BBMP Act 2020 so far. He has not implemented. So he has violated the law. It is his job to implement the law, and he is not implementing it because it is not implementable. Because elections are not yet number 5, 4, 5, say up to 8, or political party state in charges of different political parties. They are the ones, they go around misleading people and saying things which are not true, making them believe which are not likely to happen. They don't have a manifesto and number 1. And then regarding the delimitation, gerrymandering.
To 2 months.
BBMP, if you want to continue like this, I have no problem. I will because I have a lot of my
Statement party.
I don't want to be inserted.
Take down. The public litigation has been filed, seeking following relief. Mr. Holy Christ Ramanathan, the party in person, makes a statement that he wants to consult a legal person, a person with legal knowledge, and file proper petition. As such, he may be permitted to withdraw this writ petition with liberty to file afresh. The writ petition is accordingly dismissed as withdrawn with liberty to file afresh. We have given you liberty to file afresh in a proper manner.
Lords.
The challenge to a tender notification.
Lords, may I just be permitted? Lords, in this matter, some people had challenged this notification and the matter came up before the single judge, and the learned advocate general has made a statement there, my lords. May I just read that statement to your lordship? The learned additional advocate general, Shri Dhyan Chinnappa, on instructions from Shri Narendra Holkar, additional transport commissioner who is present before the court, submits that the technical bid will not be opened on 17/3 and the decision whether to proceed with the tender process or not would be taken shortly. The above submission of the Advocate General is placed on record. List the matter. My lords, in view of this, my lords, your lordship may adjourn this matter to beyond 29/3 when the learned Advocate General can, my lords, inform us as to what is happened.
This public interest litigation.
Yes, my lord.
Litigation, Lord.
Now come to a prayer.
Yes, my lord. At page
Page 30.
Lord, page 19, my lords, is the prayer.
That is something else.
Page 19.
Page 19.
Lords, before that, if your lordship wishes to, my lords, come to page 14, my lords, where we have the challenges. What is the problem?
Already some petition has been entertained that is pending before a single judge. For the same cause, why the PIL should be entertained?
Because, my lords, this would be individual, my lord, traders. They have a personal interest in the matter. What I have filed is, my lords, for all, it would apply to all people who have bought their vehicles before 2019. And the tender process, my lord, the challenge is that it is actually targeted at.
What is the name? And already there is some direction also.
Yes, I appeared in that matter last time, and we have not, of course, not opened the bids as of now because of some decisions which have been taken at the government level. But in any event, Lord, the challenge there also is that you should not call for tenders, and various interested parties have filed petitions saying those tenders should not be called for. It's a similar ground law. Now someone to challenge that tender practically becomes a petitioner before your lordship, because that is the prayer number 2.
Milord, and in fact, there is, I'm told, a newspaper report also.
He's asked to replace his existing number plate with that HSRP plate, isn't it? Why did you ask only him?
No, not only him.
No,
No, nothing like that. What he is saying is that everyone should be allowed to go to whoever they want to replace it.
Right.
You can't call for tenders and have only one or two entities to do this. And that is the allegation that is made in this
But
petition.
may I please, Milord, please come to page 14. The allegations are set out clearly in page 14. Milord, please come to page 14 of my petition. On a further study of the tender dated so and so, it becomes apparent that it requires person to supply number besides other experience in executing HSRP project in at least 4 states in India for a minimum period of so and so. Manpower greater than, Milord, the newspaper report said that this is a tender which has been tailored only to suit one person. And that is the public interest. It can't be, Milord, state can't be giving away largesse like this. Please see, Milord, a positive net worth of at least.
Whoever is individually aggrieved may file the petition. Already some petition has been filed, which has been entertained. That is pending. Some direction is
But
also.
this will be,
I advise we should entertain the PIL.
Milord, because it goes into the malified of the whole thing, Milord. Your lordships will see a positive net worth of at least 150 crores as on March. Milord, this is all targeted at one person. Newspaper report, this is what, Milord, and therefore, and now even the Advocate General has made a statement that they might have a relook at. A cumulative turnover of an amount of 300 crores in the last 3 financial years preceding the bid due date as on case of a TAC holder. So, Milord, your lordships will see, Milord, there are a lot of other people who may also be capable of doing this. You can't bring out a tender where it is apparent that you just want some big person to get the tender. Please see this. A cumulative turnover of 300 crores.
Challenge is the same.
What is the ground?
They are saying that on the basis of the Motor Vehicles Act, you cannot call for tenders at all for HSRP because HSRP has actually, there are certain agencies which are enlisted by the central government and only they can participate. Out of them, Lord, the state.
Who are the petitioners there?
There are petitioners, Lord, who don't qualify in the tender. Right. But they claim that they are entitled to sell HSRP number plates. Right. And therefore, they have challenged the tender. Another set.
They are individually affected, saying that the tender will affect their right to manufacture.
Yes, that is one. Then there is another set of them who says we've altered the tender conditions slightly. That alteration is affecting us. Therefore, different sets of petitions, not challenging different parts. But really, the prayer here seems to be completely a proxy battle, not on behalf of only persons who are going to benefit from this tender being cancelled. It can't be anyone else who will come to court challenging this.
It's an advocate who has come to court. He has, Milord, your lordships will see how this, and when the Advocate General has made a statement that they also do find there's something wrong. All I'm requesting is your lordship may list it after 29th. Let's see what statement he makes.
Get it.
with the matter, therefore we will not entertain the PIL.
Then your lordships may permit me to withdraw, my lord, maybe the next.
Already matter is there, and whatever decision is taken in those writ petitions, that will depend. They have already made a statement that they are not going to proceed further.
Therefore,
With respect to
lordship puts it off by my lord. Let us see what because my lord, his challenge would be different. His would be a personal interest and a commercial challenge. This challenge is if the whole process is mala fide and that it has been tailored. The tender conditions have been tailored to favor one person. And it is, my lords, only in respect of people who already had vehicles on 2019 and nothing to do with the new, my lords, HSRP number plate.
Whatever it is, if you want to withdraw, you may withdraw. Otherwise, we will not entertain.
Lord, your lordship may permit me to withdraw with liberty to, my lords, maybe approach the single judge. But the single judge will not be able to do a PIL.
Individual person, not PIL.
I agree, my lord. That is the only reason why we are here.
Petition this public interest litigation has been filed, seeking following relief. This is Kamini Jaiswal, the senior advocate appearing for the petitioner after arguing the matter at some length, makes a statement at the bar that the liberty may be given to individual persons who feel aggrieved against the tender issued by the respondent, and this writ petition may be dismissed as withdrawn. In view of above, the writ petition is accordingly dismissed as withdrawn. We do not find any reason to observe that whosoever is aggrieved has a liberty to approach the court.
Oblige me.
How much is the delay?
$115 days delay, my lord. In view of is in between that days. 24/3/2020.
It is covered by the Supreme Court judge order.
Please.
All right. Yes. Will condone the delay. Yes.
Please.
Yes. What is the ground of challenge?
But the ground of challenge is the first respondent was appointed on 17/6/2008 as a P1 temporary at respondent number 2, my lord. Respondent number 2 is not granted for an approval of aided, my lord. Grant in aid is not provided to respondent number 2, but it is to the respondent number 3. There is a report on 9/2/2016. It says that so far as respondent number 1 is concerned, it is refused on the count that the grant in aid is given to respondent number 3 and not to respondent number 2. These additional documents are also produced.
Just.
Please. The impugned order is at page 17, my lord. Starts at 17.
This submission made in para 2 of the impugned order,
Please.
that submission itself is incorrectly recorded, is it?
Certainly, my lord. It is. To substantiate that fact, additional documents are produced. Page 77 is the appointment order.
Have to stay.
But none appear.
Third, in view of the Supreme Court order such and such, the delay in filing of the appeal stand condoned. Learned counsel, learned AGF for the appellant. Admit to notice to respondent. Who is respondent 2 and 3?
Respondent number 2.
Institution and the college.
Please.
Respondents returnable at an early date steps within the PF within 1 week.
Sought for stay. My lord.
After hearing the counsel for the appellant and going through the record, we feel appropriate that the next date of listing, the operation of the impugned order such and such shall remain in state.
All right. Number 7.
The papers of the petitions.
Eh?
Papers of the petitions are not filed.
Two of these objections are that whether the objections were filed by the opponent, it was not filed. The first date of hearing is the interim order was passed. That's why I have written that no objections were filed by the opponent. If the interim order, this petition is filed, this appeal is filed.
You will have to file the complete set of writ petition.
Complete set of petitions were filed. Complete set of petition was filed. The order was
Copy of a statement of objection,
yes, no.
its verifying affidavit, and its annexes
Yes,
filed
no.
by respondents, RA or rejoinder, any in WP to be furnished.
No, it was not filed. That's the objection. On first date of hearing, before filing objection itself, interim order was passed. It was not filed. Respondent did not file any counter now till today.
He's
What
saying
is-
that without a first stage, on the date of first listing before the single judge only, interim order is passed. Against that, objections are not filed.
Not filed.
Till now,
Now, this is pending only against interim order, he has rest. Where the
Certain portions of the interim order. I am the petitioner. The portions of the interim order says, as in the 985, I have to deposit the entire.
statement of objection has not been filed till now.
page 10, impugned order of the single judge, interim order.
Yes.
Lord's order is now on this day it is stand vacated for the reason that he has to deposit 25% of the amount. He has not deposited.
Deposited. That is deposited. Without prejudice to the writ appeal also you have deposited. You have deposited.
Right.
No, ಇನ್ನ ಇದೆ. ಪಾರ್ಟ್ ಬೈ ಪಾರ್ಟ್ ಇದೆ. ಮತ್ತೆ ಫರ್ದರ್ ಕೇಳ್ತಾರೆ ಅವ್ರು.
ಕೊಡಿ ಮತ್ತೆ.
ಆಗಲ್ಲ.
There's this timetable given for payment.
Yes, sir.
That was not even payment, deposit.
Full ಅಲ್ಲ. ಇನ್ನ ಇದೆ. ಇನ್ನ next week ಕೊಡೋದು.
Page 13.
Yes, okay.
Schedule, payment schedule is given by learned single judge.
Yes, sir.
You are agreed by what?
That they say there is arrears. There is no arrears.
Learned single judge hasn't decided anything.
Yes.
All that the learned single judge has said is stay subject to depositing as per a payment schedule.
Payment schedule. There was an arrears I have to deposit.
No less is decided.
Not deposit.
Go and file a stay vacation, modification, whatever it is. How your writ appeal is maintainable against this order?
Can you see, I have no, there is no arrears. That is why I have.
How your writ appeal is maintainable against this interim order? What issue has been decided by this order?
Only
Is
deposit.
there any issue decided? Any list has been decided?
No, it is not.
Then
Again,
how the writ appeal is maintainable? Writ appeal is maintainable only when any list is decided. Even at the stage of interim relief, if any issue has been decided finally by the single judge, only then your special appeal or writ appeal would be maintainable. Now you have two options. Either we pass the order on merit or you withdraw it with liberty to move an application before the learned single judge for modification or vacation of the order.
Because your prayer for interim relief has not been considered and no order is passed. Only once they file their objections, you can always argue on the prayer for it.
The interim order will be taken modification.
But this intra-court appeal has been filed challenging the order dated such and such, whereby the writ petition preferred by the appellant.
Appellant.
The interim order has been passed. The conditional interim order has been passed by the single judge. After arguing the matter at some length, the counsel for the appellant makes a statement at the bar that he may be permitted to withdraw this writ appeal with liberty to move appropriate application for modification of the order under challenge. The writ appeal is accordingly disposed of with liberty to appellant to move appropriate application as prayed.
Another two writ appeals are there, 261 and 269. It will be called in similar or 261 and 269. Writ appeal 261 and 269.
What they do is they prepare a separate list since it's only withdrawal.
Call it, I have no idea.
Separate list ready.
It has to be shown in the list that is
Disposed of.
Same lines.
261 and
269. 261 and 269.
all get it printed first in some list and then.
This is an appeal, defendant's appeal from a decree of money, my lords. So, defendant, my lords, is a power generating company, and the services of the plaintiff were engaged for the purposes of transportation of coal from western coalfields to the power plant of the defendant, my lords. Now, the duties of the plaintiff, my lords, was to transport the coal of the same specification.
You are plaintiff or defendant? You are defendant. You are defendant in.
My lords, the coal that was to be transported by the plaintiff was to be of
What
the
has
same.
been done?
My lord,
What has been done?
my lords, it's been partly decreed. The claim amount was 57 lakhs, 43 lakhs has been decreed, my lords. My lords, the major issue here is, my lords, there was a letter that was issued by the plaintiff saying that after final settlement of all the accounts, 78,000 is to be paid to the defendant. That payment has already been made, my lords. This, my lords, was never brought up in notice of the Honorable Trial Court, my lords. However, my lords, the trial court has proceeded to hold that that letter was given under coercion and duress, my lords. My lords, there is no pleading in the claim. There is no issue frame, my lords. Even in the evidence, my lords, there is no whisper of this letter saying that the payment has been made. Only at the time of final arguments, my lords, there was a contention taken up that this letter and the payment was made under coercion and duress. My lords, the Honorable Trial Court also holds that there is no such pleading issue or evidence, but again proceeds to hold that it appears that as if the letter was made and the payment was made under coercion and duress, my lords. My lords, if I may point out the relevant part of the judgment, my lords. Just one paragraph, my lords, at page
Just a minute.
please.
Commercial 97 of 2022.
Up to 50%.
Are you ready to deposit the amount decreed?
So, defendant is a government undertaking. There is a slight financial difficulty, my lords. So, if a lordship would,
We can reduce the amount.
lords, the defendant in fact is in the process of setting up another power plant that is being commissioned. Also, summer is approaching, my lords, again supply will go up, demand will go up, my lords. Kindly, I request the Honorable Court to kindly take a look at the
If you are not ready to deposit the amount, then we will not entertain.
Not a reduced amount, maybe
Huh?
a reduced amount. I request the Honorable Court to kindly consider to reduce the
50%.
50%, not less than 50%. We have
I request the Honorable Court to allow 25%.
no negotiation.
I apologize.
50%. If you are ready to deposit, we will admit the appeal and ask them to file response. Third, the Commercial Court appeal has been filed under section 13, 1A, Commercial Court Act, challenging the judgment and order dated such and such, whereby the suit referred by the respondent of the plaintiff has been partly decreed, and appellant defendant has been asked to pay rupees 43,23,566.20 to the respondent plaintiff along with interest 9%. Full stop. Considering the submission made by the General Counsel for the appellant, as well as, what is your name? Also appearing for respondent, we pass the following order. Admit, issue notice, respondent is already represented by so and so, as such no steps are required to be taken. The respondent may file their response within 4 weeks. Just give a date after 5 weeks.
1/6.
In the meantime, in case the appellant deposits 50% of the total decretal amount along with interest up to date within a period of 3 weeks, 3 weeks from today, the operation of the impugned judgment order shall remain stayed.
We have 31 days in filing.
Today. Yes.
Days delay is there.
I beg to appear for appellant in number 10, please, my lord. Suit 1 for my lord's recovery of money, my lord.
Lords, I suppose my lords are on serial number 9.
Yes.
Please, my lords. I'm sorry for the interruption. My lords, the appeal is under the Commercial Courts Act, my lords. Initially, I had filed an MFA. My lords granted me liberty, and therefore I have filed this. There was a 31 days delay. I have filed an application to condone the delay, and I have been exempted, my lords. The notification by this honorable court. I have annexed the notification also, my lords.
Section 34 dismissed. Hindustan Petrol.
Please, my lords. 34.
Nothing that in this. On what grounds you are challenging the order?
My lords, the mandate given by the Act, my lords, the arbitrator has superseded that, and then the award is totally illegal. That is 34
Beyond that time.
218.
Yeah.
Last week also
We have entered in or we dismissed it?
we sent it back. We set aside and appointed a new arbitrator, Mr. Subhashadi.
The consent of the other side.
The consent. In this, if somebody appears, we can do this. Let him take out notice.
Who appear for the respondent? Is there a caveat?
Notice is yet to be ordered, my lords.
Issue notice to respondent 1 and 2. 1, sorry. 1. Step, the PF shall be taken within 1 week. In addition to the regular mode, the appellant may take hand notice. Respondent. Give it date after 10 days. 5th April.
Grateful, my lords. I will do that.
On that date, affidavit of service shall be filed.
Grateful, my lords.
Number 10. Dinesh Garbudia.
No, sir. To appear, my lord, for the appellant in this matter, my lord. This is the appeal filed by the defendant number 2, my lord, in a suit for recovery of money. But the contention of the plaintiff, that is the respondent number 1 before your lordship, was that, my lord, he has rendered and given services of software installation and hardware installation to the Medical College Institute, my lord, and that they have not been paid the money. But the learned judge, my lord, makes observations in the judgment that there have been complaints made by the defendant number 2 regarding, my lord, the malfunctioning and the non-functioning of certain installations. Yet, my lord, allows, my lord, the suit in toto with a rate of 18% rate of interest, please, my lord.
50%. He wants interim order. Otherwise, you can issue notice.
What is your ground of challenge?
The ground of challenge, please, my lord, that
unmute yourself. First, unmute. Yes.
attended to, my lord, by the plaintiff. My lord, the liability has not arisen in as much as, my lord, the contract itself was not completed. I'll deposit, my lords, 50% within 4 weeks, please, my lord. At least if the party, my lord, the respondent, my lords.
50%.
Pass the order.
The issue emergent notice to respondent number 1. Learned AGA accepts notice for respondent number 2. Copies to be served. Meanwhile, relist on date code. Relist on so and so. Registry to secure the TCR by the next date of hearing.
Admit issue notice.
Will admit on this, sir. Admit. Heard learned counsel for the appellant. and peruse the material on record, including the impugned judgment and decree passed by the trial court. Full stop. Learned counsel for the appellant submits that the trial court, in addition to not considering or appreciating the material on record, also failed to consider and appreciate the oral and documentary evidence which indicated that the machine supplied by the respondent number 1 dash plaintiff to the appellant dash defendant number 2 was defective. Is it defective? Was defective, and consequently the impugned judgment and decree passed to the trial court directing the appellant to pay the decretal amount in favor of respondent number 1 is contrary to the material on record, and that the same deserves to be set aside by this court. Submission of learned counsel for the appellant is placed on record. Issue a measure notice to respondent number 1. Learned AGA for
There he wants to take notice for respondent.
so and so accepts notice for respondent number 1 and seeks time to file objections. Full stop. Here to heard learned counsel. Relist after 1 month on date. Meanwhile, the operation and implementation of the impugned judgment and decree passed by the trial court is stayed subject to the appellant depositing 50% of the decretal amount with up-to-date interest as on today within a period of 4 weeks. Full stop.
Before this honorable court, please, my lord.
Before this honorable court. Before this court.
Obliged.
24/5. Defendant's appeal, my lord. Challenge is manufacturer and exporter of industrial starch, and the plaintiff, the forwarding and customs clearance agent, his services were engaged for exporting of consignment. And he had given a detailed quotation listing charges under various heads. Thereafter, he has levied charges which are not specified in the quotation and are doubling. In fact, he has mentioned as warehouse rent per container. It is also collected warehouse storage charges, which was objected to by the appellant. And similarly, bonding rent and bonding storage charges. He has collected various charges.
Correct. Interest is 1,56,000. So.
Percent, and from the rate of filing, 80% has been levied. The claim is almost doubled.
Can you serve the respondent?
He's on caveats, already on.
Where?
Mr. D. Hanumant Rai.
Where is he? The amount is very little, so it can be amicably also settled by way of mediation or something. Where is caveator counsel? Have you served? You have served. Caveator.
D. Hanumantrayappa.
Dispute appears to be only with respect to the interest parts.
There are other charges.
Some other charge.
There is other charges. Yes. Like rent and storage charges. The container is charged.
Have you served the learned counsel for the caveator?
Yeah.
Already, sir.
Pass.
We'll pass.
Pass.
Tell him to come. We'll pass.
But one,
Appeal filed by the Karnataka State Financial Corporation. Petition filed under section 31(1)AA of the State Financial Corporations Act has been rejected by the commercial court. That's total amount claimed that in the petition was 2,61,07,448. During the year 2006, that's plant and machinery that belongs to the industrial concern that was sold for a sum of 74,50,000. That realized amount that has been adjusted towards the loan outstanding. And the balance amount that was not 1,79 lakhs. That now the learned judge observes in the order that there is no indication of appropriation of the amount realized from the sale of plant and machineries. Therefore, the claim is unsustainable. But even assuming that the corporation has realized 74,50,000, but as against the total outstanding of 2,61 lakhs. In respect of the remaining sum, the appellant corporation was entitled to recover from the respondent.
Issue emergent notice to respondent. List after service of notice. Registry to secure the TCR by the next date of.
Number 13.
I appear for the appellant's counsel. I appear for the appellant's counsel, my lord, sir. I mean appeal. Questioning the order of the trial court by which my application to section 9 is dismissed. More than the dismissal of the application, my lords, a final finding has been recorded in the matter of limitation that my claim is barred by limitation. And a finding has also been recorded that the arbitration agreement in one contract cannot be extended to the other contract. Actually, there is no second contract, there is only one contract. My case was that one contract was given and under the same terms and conditions, I was asked to do the second one. In arriving at the finding or limitation, the court ignores the payment the respondents have made on 14/8/2018, which I have placed on record by way of a check before the trial court also and also before this honorable court. Now, my lords, with the type of findings recorded, even my entire case will go for a toss because CMP is pending before this honorable court.
Was there an interim order when the section 9 was filed during the pendency?
No, there was no interim order. There was no interim order. The type of findings recorded, what's it still?
He is concerned with the findings. So we'll issue notice. Once they come, we'll expunge those. We'll leave those contentions open to be decided either in the CMP or before the.
Ask him to serve outside court. And we can have it next week.
Right. Sir, please kindly serve the learned counsel for the respondent through hand.
Yes.
The respondent as well as the learned counsel through hand will list it next week.
Matter can be disposed of. Matter can be disposed of.
It can be disposed of, my lord.
Yes, that is why we are saying that if you can serve him and with the consent of parties counsel, we can dispose it of.
Yes, my lord. Then, my lord, the second submission I have is this, my lord. Assuming that the finding that this agreement does not cover the Hyderabad work is always correct. Even then, my lord, I was entitled for relief on the work done at Bangalore. That has not been examined by the trial court. Is my second submission.
Section 9 findings only prima facie.
That is one thing, my lord. That is a major thing, my lord. That is a major thing which would hurt me throughout. And second is, my lords, after notice, my lords may consider giving some protection in respect of the Bangalore work.
Let them appear.
We have a short date next week.
Emergent notice returnable by
Great.
next Friday, next Thursday,
This
Next.
Monday.
next Monday. Next
28.
Monday. In addition, thereto, petitioner also permitted to take out hand summons to respondent as well as serve learned counsel for the respondents who appeared before the trial court. Full stop.
Great, great.
Number 14.
Saturday, the RPA cover to pay the arbitrator and any evidence showing that the arbitration award when it is served, according to the copy I received, 2/8/2019.
You find some memo?
Yes, my lord.
Just tell us a few dates. Tell us the date of the award. Date of the award is 23/7/19.
Yes, my lord.
When was it served upon you?
2/8/2019.
2/8/2019. From there, 90 days expires on 2/11, is it?
And it can be extended up to 150 days.
Correct. No, that's what. The first period is 3 months, that is 90 days, 2/11. Then the condonable period, extendable period is 30 days. That comes to end on 2/12. When did you file the section 34?
It is 30/11/2019.
30/11. Right. So which is the document to show that it was served only on 2/8?
I remember that RPA cover the same arbitrator and the commissioner.
No, this acknowledgement. How did you get this acknowledgement?
I issue, I taken through RKE.
Right. Section 34 is dismissed on. Dated 24/2/2022, calling upon the appellant to produce documents to show that the arbitral award was served upon the appellant on 2/8/2019, a learned counsel for the appellant has filed a memo dated 19/3/2022, enclosing a copy of the RPAD postal acknowledgement obtained under the Right to Information Act. Full stop. The said document, the said RPAD postal acknowledgement prima facie indicates that the arbitral award was served upon the appellant. The arbitral award dated 23/7/19 was served upon the appellant on 2/8/2019, and consequently, the section 34 application petition/application filed by the appellant before the trial court on 30/11/2012 was within the period, extendable/condonable period of 30 days in terms of the proviso to section 34(3) of the Arbitration and Conciliation Act 1996. To stop under these circumstances, issue emergent notice to National Highway Authority. Full stop. Under these circumstances, issue emergent notice to respondent 2 and 3, or 1 to 3. 1 to 3. List after service of notice.
Number 15. Chidanandaya.
Appeal.
of denying. That's claim number 3, 7 and 9.
Dismissed. Claim number 2, 3, part 7, 9, 10, 11, 13, 14, rejected by the tribunal. Total
There are totally 12 claims.
12, 13 claims.
The relevant arbitrator denied claim number 2 and 3 and claim number 7 and 9 on the ground that so far as claim number 1 and 2 and 3 is concerned, the relevant arbitrator
No, please point out from the section 34 order.
Yes.
The patent illegality.
Yes. Kindly see that the award of the arbitrator, I just say to lordship, the arbitrator award clause 22 and 23 of general conditions of the contract statement.
Page.
Where is the award?
149. Award is in volume 1 minute.
195.
It's page 149.
$149.
Yes.
What do you want to point out?
Just my brief, so far as
What do you want to point out from page
what I want
140?
to point out that the relevant arbitrator denies this claim on the ground that I have submitted the running account bills at the rate of 2,800. I am not entitled to the unit rate mentioned in the contract. So this is contrary to clause 23 and 24 of the general conditions of the contract. Right? This is with regard to the unit rate of the quantity over and above the original quantity.
Are we supposed to see this in 37?
That's the reason that the arbitrator has not taken into this. No doubt that he considered clause 22 and 24 minute. Learned arbitrator states that I have submitted the bills at the rate of 2,800. I am not entitled. But my first contention is that when the clause provides for minute, if I work over and above the
This we
quantity,
cannot interpret. No.
Was this ground urged before that? And what is the
court doesn't consider any one of these minute.
No.
My contention was that this is contrary to award of the arbitrator.
you are aggrieved by rejection of certain claims.
Yes.
Has each one of those claims been independently considered by the section 34 court? Please show us from the section 34 order that points formulated by
Yes. Page 55, para 9 it starts.
please tell us which are the claims you are aggrieved by before
Claim
section,
number 2, that it is
No, no.
supply of sand.
section 34.
Yes.
Which were the claims which were rejected, which you are aggrieved by?
Claim number 2, 3, 7 and 9.
2, 3, 7, and 9. So these 4 claims were rejected by the learned arbitrator. Against that, you filed section 34. Where are the findings on 2, 3, 7, and 9?
Page 57.
Right.
Para page 22. Kindly 10 lines from the page.
First of all, have all these contentions been considered or not?
They are considered that the kindly see the court. It says that it is proper. That's all. It doesn't say. In 3-4 paragraphs, this argument.
See, the problem is we can't reappreciate.
I'm not asking reappreciation.
You'll have to show something so glaring.
It is glaring for this reason.
No, not by submission. From the section 34 order,
yes,
you'll have to show something so glaring that
I just want to consider It doesn't give the reason. My contention before the commercial court was.
Section 34 or even 37.
Yes.
Merely because document or evidence has
There
been
has to be patent illegality.
Yes.
Only then appeal can be entertained.
Once the award
We
is
cannot
contrary to the award,
reappreciate the evidence.
once the award is contrary to the express language employed in the agreement, that is taken into.
So show us the contract.
Yes.
Show us the
Yes.
finding
That's what I-
that finding is contrary to the.
Come to the contract related is I produce value 3 minutes. Page number, what we kindly come to page 174, value 3. But in this, just so far as claim number 2 is concerned, how it arose. This is weighing of underground cable. The BBMP changed that. They said you have to provide extra cushion to the cable by providing sand.
Right.
Therefore, they called upon me to provide additional sand over and above the DWA quantity. So, therefore, I was asked to supply additional quantity. If I supply additional quantity over and above the quantity, it is covered by clause number 22 and 24 of the GCC.
This is claim number 2.
Yes, claim number 2 and 3 same.
2 and 3.
Supply of sand and earthquake disposal. As a consequence of supply of additional sand, there is an increase in the quantity of earthquake disposal.
Right.
Page 174.
Right. Right.
Power to vary and omit to work. Your worship, I kindly come to see the price with regard
So
to
additional work done by you.
Yes.
Additional work done by you.
Yes.
Is covered under clause 22.
24.
22 and 24.
24.
Change of quantity.
Yes.
All right. Now, claim 2 and 3 relate to additional work done by you, either by additional sand or additional work, earthwork done.
Additional earthquake disposal, transporting.
Where show us the finding in the arbitral award.
Yes.
Why this claim is rejected.
That's right. That's page 159. Sorry, 149.
Third volume.
The first one.
Within value 1. Yes.
Right. So this is claim number
Yes.
2 and 3.
Yes. Or 8.84.
149. 140.
Yes.
We're just seeing whether clause number 22 has been considered.
Considered.
Quantity of this.
The level arbitration is considered.
That's right.
Yes. Let the level arbitrator relies on let exhibit P1 C74. And I just straight away take the clause 8.88151 and I just read. That is the reasoning that the clause 24.3, 22.1 extracted. Page 151. Exhibit C174 is the official memorandum dated 54/2010, issued by the respondent taking note of the request of the claimant to approve the rate for additional quantity of sand as per the conditions stipulated by the BBMP based on the rate specified under DD. Taking into account the rates of Public Works Department, approval was accorded for payment of rupees 2,800 per cubic meter, inclusive of sand disposal. That the DWA rate for that was 8,8846 plus 4,039. As against that, they brought it down to 2,800. Then we para. Yeah, the claimant contains that exhibit
C153. Next page.
The claimant is entitled to contractual rates.
Yes. 1 second.
Yes.
Even though the claimant is not a signatory
Yes.
by conduct, so this may not be correct. By conduct, because unilaterally to change the Notice to respondents, list after service of notice, registry to secure the TCR by the next date of care.
Today morning, we have received the NOC Wakalat along with the transfer brief. Juvenile Naganand will enter appearance on behalf of the appellant. I request for 2 weeks time. I will file my NOC Wakalat during the course of the day. Submission.
The objection is they are not deposited any amount. The condition precedent. It's a money decree. Arbitration suit.
Why should it be deposited? Is there a provision? The provision. Even to file section 37 appeal, to file they have to deposit, is it?
Yes, 100%.
Let's have a look. Which is the relevant portion? That when section 37 appeal is filed, they have to deposit the amount as per the arbitral award. Where is the relevant portion?
Relevant portion, your lordship, is in page 2. Statement of the report.
How can I? Sikkim. Last Calcutta. In the end, last judgment.
Fourth
Paragraph?
Paragraph 4.
This is a Board of Trustees versus ABG Kolkata. Right.
Unless they deposit the entire amount, whatever has been ordered.
Right.
The honorable arbitrator.
Right.
Appeal itself is not maintained.
Appeal here.
Yes.
Where is that? Where is it finding?
Shall I read it? No one appears.
No, that is for the purpose of stay. Sir, that is for the purpose of stay. For the purpose of stay, it's discretion.
Yes.
Whatever we do. Today, they're not asking for stay. That will consider.
Yes, been filed for stay.
Correct. No, we thought that even to file the section 37, they have to deposit. Order 41, rule 1, I think, they have money decree, they have to deposit. So we thought section 37, there is a similar provision. It's not.
The money decree.
Naganand is up here.
I'm sorry, Lord, I'm instructed to appear. Slight handicap. We haven't received the entire papers, Lord, so we'd like to file power and then we'll get ready.
All right. It is submitted that Srimati Suvana Naganand has entered appearance on behalf of the appellant, registry to print the name of the learned counsel and delete the name of Shri B.S. Manjunath, bracket Su Associates for the appellant. Relist on after 2 weeks. First week of April.
Please.
For the first or second?
Sorry?
Second.
Second. Sir, 2nd April, sir. Naganand.
Yes,
second.
Please.
Second April is a holiday. 1st April.
Number 17, motor petition.
Leading to out of school children. There were meetings and some reports I have received. Meetings. There are some mistakes which I had pointed out in the survey reports. They have rectified and they have forwarded. I had discussions with officials about 3 weeks because there is it involves some translation also. I received it on Saturday evening. Small pocket in BBMP area is remaining. I'm sure it will get done.
It has been provided. Then amicus curiae wants time to look into it.
You have been provided the data by the urban development.
It's all in Kannada also, because I'll get it translated. I had discussions, officials came, and I have had discussions. So I'll formulate and comprehensive report on that.
Right.
May I make a submission, Your Honor? I'm party in person.
The necessary data has been provided by the counsel for the respondent. He may be given time to go through the same in order to assess the report. The copy of the necessary data may also be provided to you appear for respond number 4. Give it after 4 weeks.
3rd June.
Party in person to say something.
The urban development department has given the data.
Party in person was submitting.
Yes.
Madam?
Yes, Your Honor. It was a very good meeting with the Chief Secretary of the Interdepartmental Coordination Committee. And some points were raised. Like,
Madam, you have a look at the whatever all the material and we'll take it up next time.
I would like a direction from your side, Your Honor, because they kept saying that in the discussion that happened on 16th.
We're not hearing the matter today. We're not hearing the matter today. You please take copies in case they want to have a look. We'll hear it next time. Right.
3-6.
Yes, Your Honor. Thank you.
Number 18. Let us now.
Government has gave the complaints affidavit. Now,
yes.
His complaints affidavit has been filed in actions that have taken regarding appointing and giving facilities to the claim commissioner. The steps that have been taken, the complaints affidavit has been filed. In addition to that, on the last date of hearing, he had filed an IM, which perhaps has not come on record, wherein he had sought for. We have given a proposal to the court for appointing 1 claim commissioner instead of 3 claim commissioners, considering the exchequer and the volume of work involved. That application
Documents are in Kannada.
the documents are in
Kannada, you're not.
I will here it is. The Nepal official. These documents which they are produced now, it pertain to DJLD and KJLD rights. Nothing to do with the earlier Karnataka one which has happened in 2018 and also in 2019 Kanakpura. Those documents are not being filed. This is Justice Kempana who has been appointed as a commissioner. DJLD, that has nothing to do with this present case. The 25/2/2020, his order is very specific. 25th February 2020. Till date, they are not compliant with that order. That's my responsibility. 25th February. district judges have been appointed as time commissioners to not in respect of the other two Royds, which is directly involved in this petition. The complaints of that is also. That is separately, that matter is separately being taken up. My current friend is something also. It has nothing to do with this case. 25th February 2020. All the writ petitions, these three writ petitions, only numbers are mentioned. Detailed order was passed.
See, 25/2/2020 order, paragraph 26.
Yes.
Mr. Gauss Patil is appointed as regards the incidents took place on 3 dates.
Yes.
25th January, 4th February, 12th April.
Yes.
Then Mr. Benakanalli, retired district judge for for one particular period.
Yes.
Then claim commissioners, remuneration, etc. Your compliance is in relation to these directions or some other directions?
No, sir.
Now let us read your compliance affidavit.
Yes.
May make one. Document number 1, my.
Let us read the compliance affidavit.
Complaints affidavit not filed today.
5/9. That's right. That's
Yes.
correct. I've been appointed, so on.
Para 4.
The only compliance is para 8.
Yes, sir. And release of amount para 5.
No, last time, matter was posted on 2nd of March.
Yes.
On that day, we said make submissions regarding compliance.
Yes.
So after 2nd of March, the only compliance is 3/3.
Yes.
Isn't it?
Yes. But the previous, these were not made, brought to the record.
Record earlier.
May make one submission.
So para 6 onwards.
Yes.
Para 6 onwards are facts which are not brought to the notice of this court earlier.
And that is in complaints of the dishonorable court's order at para 26.
Right.
Document number 1, my lord. It is in Kannada.
The translated copies.
Translated. Or your lordship kind.
No, but my lord has to.
Because
Let's see. Like this only. We look at the compliance.
7 of
There is in respect of writ petition number 9287 of 2020. It is not in this connected cases.
Document number 1.
Document number 1.
all the documents except last one.
All these documents.
But there is some other writ petition, not with regard to this writ petition.
There is no complaint.
This is with regard to DJLE and KJLE. This writ petition is filed in the 2018.
What is this 9287 of 20?
There's another connected writ petition in this, my lords.
Is it connected with this batch?
No, my lords, but
Is it connected? If it is not connected,
yes,
then these documents have nothing to do with that writ petition.
yes, my lord. My humble submission is this, my lord. That yes, I agree, my lords.
Right.
But as far as this writ petition is concerned, my lords, we have appointed 2 claim commissioners.
First of all,
Yes,
which of these you have produced 8 documents?
yes,
Sorry,
9 documents.
9 documents.
Yes,
So let's go document by document.
yes,
Document number 1, not applicable.
yes.
Right. Then document number 2, not applicable.
1 to 3 not applicable.
1 to 3, not applicable.
Yes. Up to 7 it is not applicable. 8 and 9 only for this case.
4 also.
So up to 7, not applicable.
8 and 9.
Then let's look at 8 and 9.
On 8 and 9 also it's a partial.
Right. 8 and 9 on 25. That's why I asked you. Say we asked you
Yes,
that 25/2 is a recent thing, what you have done.
yes,
Only these you have brought on record.
yes.
What about the compliance earlier? Where are the documents? Where are the documents relating to the directions issued by this court
Yes,
on 25/2/20?
yes, 25 to 20 my lords. The order at para 26 my lords. There are 10 directions that are issued. May I read that, Lords?
Your compliance affidavit
Yes.
should be very specific.
Yes.
Why did you produce in relation to some other writ petition?
No, my Lords. In that also we have done and subject. Yes, Lords.
They make one submission. If that writ petition may be posted before this honorable and connected with this case, because that writ petition is already disposed of by this.
If it is already disposed of, this they have produced they have filed a compliance affidavit,
yes,
producing documents which are not connected with the order dated. So,
Your Lordship.
I'm not aware of.
On 18 January also.
You have to file a different affidavit. Because
you
have to file a different affidavit, give only those documents.
Yes, I'll short accommodation, Lords. I'll file a better affidavit with only.
I think the problem seems to be whatever the officer has come and given to you.
No, not like that. May make one, sir. Now, already 3 years have been enough. 2019, they burnt all the buses.
This has to be rejected. We'll reject this affidavit. You file a better affidavit and
I will withdraw this.
a perusal of the compliance affidavit dated 19/3/22 filed on behalf of the respondents will indicate that the said affidavit and documents are not in compliance with the directions issued by this court wide order dated 25/2/2020. Under these circumstances, as a last chance released after 2 weeks.
Reject this.
Under these circumstances, the compliance affidavit dated 19/3/2022 is hereby rejected. Full stop.
Respondent may file.
Respondents are directed to file a better affidavit as a last chance on or before 2 weeks have been dated. 19/4/2022. After serving a copy on the learned counsel for the petitioners.
But your Lordship looked into the photos which I produced. Buses were all burned, public buses were burned in character of violence.
Right.
May it please, Malad. Malad's 19 is absolutely a non-adversarial proceeding requesting for implementation of the provisions of the Juvenile Justice Act pursuant to an order of the Honorable Supreme Court in the matter of Sampurna Bihuria, Malads, who's also one of the petitioners in my case, Malads.
Just a minute.
Yes,
Your case has not yet been called. Wait for your turn.
I'm so sorry, Malads.
18.1, my lord, the amended writ petition is not filed.
18.1.
Sir, Amritesh, sir.
Counsel for the petitioner permitted to find the amended copy of the petition within 2 weeks.
18.1. Some compliance has to be made.
Compliance. Amended copy.
Of the parties.
19.
19.
I appear for the respondent number 7, my lord, Karnataka State Legal Services Authority. My learned friend was making certain submissions.
I'm so sorry, Malad, for the confusion, Malad. As I was saying, Malad, this is a completely non-adversarial regarding implementation of the Juvenile Justice Act, Malad. And Malad, I mean, Karnataka, through your Lordship's initiative, Karnataka is the state, it's like rather an example state as far as the other state is concerned, Malad, on the implementation part of it. Your Lordships have given several directions as far as implementation is concerned. And if your Lordships now sees, Malad, the last order, that is the 22nd of April 2021. In that order, your Lordships had laid down several directions which were to be complied with by the state government and directed the state to file a reply affidavit of compliance, Malad. Pursuant to that order, on the 5th of August 2021, a detailed affidavit was filed saying that several of the directions have been complied with, but substantially, most of the directions have not been complied with. So I have pointed that out in my an affidavit filed by me by way of a chart, Malad, on the 5th of October 2021. If your Lordship is kind enough, Malad, to take that out, Malad, from the file, Malad, I'll just go through that. and I've made a chart for your Lordship's convenience in terms of various directions given in the order dated 22nd of April, my lords. My lords, I don't have the page number, continuous page number, but it is an affidavit that I have filed on 5th of October 2021. My apologies, my lords.
This affidavit of CNB.
I don't have a copy of the affidavit. What? Non-compliance is pointed out.
You are talking about the affidavit which has been filed by memo
on 5/10/21.
5/10/21 by Mr. Srinidhi.
Yes, my lord.
There is no chart next to that.
Well, if your lordship sees para 6 onwards, my lords, of that
I
affidavit.
also don't have that copy of that. I also don't have that copy.
Oh, sorry. There is no para 6 also.
I'm so sorry, there is some.
There's nothing. We don't have what you're supposed to have filed. We don't have it here.
No,
Lordship, just give me a short date, my lords. I will have that placed on record. My complete apologies, my lords. I'll coordinate with my local council there, my lords, and have that done, my lords.
Document is referring.
It's not there.
That is the difficulty when you people appear virtually.
I understand. I understand. I would have just handed that over, my lords, for your lordship's convenience. But I want that to be on record also because, my lords, it will assist your lordships to understand which of the directions have been complied with of the 22nd of April order and which have been not, my lords, and what steps might be needed to be taken, my lords, for further compliance, my lords. And next time, my lords, I'll make sure I'll come in person.
3rd June.
Oh, great.
October 20.
My lord, in serial number 20, I appear for Mr. Shiranga for KPTCL and distribution licensees. I request for a short pass off at 2:30. My lord, Mr. Shiranga is on his legs. Another court. I request apologies, but one accommodation for 2:30.
Pass it over for the day.
Please, my lord.
Serial number 20 or 21?
20, my lords.
Have you served copies of the status reports?
Please, my lord. We have served it to the learned amicus curiae. It has been served physical copy.
At request of learned counsel for the respondents, date, please.
24th.
Great.
Number 21.
Lord, I appear for the writ petition. Lord, on the last occasion, Honorable Court wanted all the orders to be placed together, my lord. I filed a memo dated 11/3/22, which has 3 orders by the Honorable Court, not 2 orders of your lordship, my lord, and 1 by the Honorable Supreme Court. My learned friend, my lord, it's dated 11th March.
Memo is not before us.
It has been filed, my lord, with 3 copies.
I also my copy. We will refer.
My apologies, my lord, it's been filed in the registry. Probably there's some delay in placing. Lord, on the last occasion, Lord, my learned friend Mr. Chaudhary, my lord, referred to your lordship's order, which will be found at page 18 in the memo. The order is dated November 21. Kindly notice paragraph 3 of that order. Sri Mahesh Chaudhary for respondents has placed before us a copy of the order dated 22/9/2020, passed in civil appeal diary number so and so, whereby Supreme Court has stated the operation of the impugned orders dated so and so, passed by the National Green Tribunal. It is stated on the basis of the stay orders passed by the Supreme Court, the impugned notices stated 23 and 31(1) were issued. As such, the matter may be disposed of at this stage. He submits that impugned notices would be made subject to the decision in the civil appeal pending before the Supreme Court. The Honorable Supreme Court has disposed of the civil appeal, my lord. That order your lordships will find at page 21.
Yes, what do you say, Mr. Maheshwaran?
That's civil appeal has been disposed of, upholding the orders passed by the NGT. That's the contention which they have to that we not have imposed the compensation at all. Because we have specific directions which has been recorded even in that Supreme Court order dated 25th of February, whereby we can impose compensation, and NGT does have the power to direct the state boards to collect the compensation.
Yes, which paragraph?
Yes. Let's look at the Supreme Court. I'm sorry, nerds, I don't have the copy. The Supreme Court judgment, paragraph number 4, members. But before that, nerds, I would want to make a submission with regard to on what basis this is being granted. It is granted on the basis of the principle of polluter pays. Until the final compensation has been decided, there is an interim compensation which is being granted for each of the industries, large, medium, and small scale, ranging between 1 crore to 25 lakhs. My lords may go to paragraph number 4 of the Supreme Court judgment.
NGT passed an order that was stayed before the apex court, and therefore you issued demand notices. Is that right?
NGT passed an order,
right,
on 14/11/2019,
right,
saying that we can impose, directing the chairman and the member secretary to impose interim compensation on the polluting industries.
Right. And that order was stayed by the apex court.
That order was stayed by the apex court.
Right.
Now,
and finally, what happened? The apex court?
That has been disposed of.
That has been disposed of, with it's actually a dismissal, but it's been disposed of, upholding the order of NGT. Now, their contention is that we cannot impose any such cost upon them. My humble submission is based on the Supreme Court judgment itself. If there are any queries with regard to this particular compensation,
I think, please read out.
May I?
The demand notice, the directions which permit you to impose interim compensation doesn't look like that those directions are confirmed by the apex court.
Yes, my lords.
Sir, Nagaran, sir,
this issue has been.
Sir, Nagaran, sir, your voice is breaking. We're not able. Both video and audio are breaking.
I'm sorry, my lord. I'll try to log another lord system. But my lord, the issue is covered by a judgment of the division bench. That is the first judgment in the memo, my lord. If your lordship would kindly take the first judgment. It begins at page 14. Paragraph 2. The notice which is impugned in the present writ petition is exactly identical to what was impugned in that writ petition. Para 2. In WP, so there is a challenge to the notice issued at an by which demands for interim compensation or for environmental compensation based on the orders of NGT have been made. Then not para 3. The demand for
that's right.
The Honorable Court found that the interim orders of the NGT did not provide any such interim compensation to be determined. Their lordship asked the Pollution Control Board, where do you get this power? And the answer was no. And at paragraph 5, my lord, their lordship.
Now, does the NGT say you are entitled to levy? Where is the NGT's order?
I have the NGT orders. I'll be able to give it this.
But doesn't that get merged with the directions issued with the apex court?
That's
modified rather.
Yes, that's
unless you can show, on one hand, we have a division bench judgment of this court On the other hand, we have the apex court judgment which restricts directions to a particular under particular circumstances. Therefore, we'll have to follow that and we'll have to set it. Right.
I have like twofold submission. Lots may look at the memo placed by the senior counsel on page number 26. It's of the memo. On behalf of the petitioner.
Right.
Paragraph number 11.
Right.
I take my lots to circumstances, but the operative portion is in the circumstances. The basic challenge raised in this appeals must fail. And if at all there is any individual fact situation which either needs to be projected or impressed upon, it must be left to such entity agency to educate concerned issues before the tribunal. We cannot, however, lose sight of the fact that for the last 2 years, the directions issued by the tribunal remain stayed. Each of the applicants had requested for blanket stay of the directions issued by the tribunal and had not confined their prayer either to the individual applicants or to the respective members of their association. Even then, all concerned must have an opportunity to present their viewpoint before the tribunal. Consequently, directions were passed to
This is a remand. And please see F. Please see para 12F.
It shall be open to the tribunal to pass such orders or interim directions calling upon the non-compliant units to deposit such sum inter alia for mitigating environmental damages as the tribunal.
So therefore, the direction issued by the NGT to deposit has been reversed. And it is left to go, they go back before the NGT and NGT has to pass orders. That is one aspect. Second aspect is this court has said it is without jurisdiction, no statutory provision.
Lords may make this submission.
Right.
Lords may also look at G minutes.
Right. Right.
The interim order of state granted on 18/3/2020 shall operate for the next 8 weeks for the compliance minutes.
Correct.
So before that,
so far as that for those particular cases are concerned, it's gone up and gone back. That's about it. So far as the legal position is concerned, we are bound by the earlier division bench judgment.
that's that order, my lords, if my lords look at page number 15, to the page number 14.
Right.
Relevant part, my lords, which the learned senior counsel is trying to rely upon.
The operative portion, para 6. Para 6, we are concerned with para 6.
That's after this, my lords.
No, para 6.1. Para 6.1. Set aside only on the ground of failure to justify the demands by referring to any statutory provision or binding order.
That's what happened in that particular case. That is why I'm requesting.
No, but what do we do about this?
Yes, my lords.
How do we? You want us to distinguish this?
That's after this, my lords, in the next matter, that is WP number 6 of 2020.
Right. Right.
That's the bench had.
At that time, the SLP was pending. Therefore, we disposed of, subject to decision in SLP.
And SLP is remanded,
now,
NGT to decide,
now that
to continue.
There is no reason to agree with this order. The earlier order, which has been passed by the division bench, specifically set aside the order. Therefore, there is no.
We have to follow this. And
The bench had decided to revisit this order because, my lords,
which bench?
previous bench was sitting on this matter when this matter came up for hearing on the previous occasion.
No, why? We don't understand this. There is an order. If you have filed a review, then it's one thing. What's the point telling us that that bench thought of something? We have to follow this.
Because it requires it requires to be distinguished because the conclusion was arrived at based on the submission they made by the pollution control board that they're not able to make out.
You show us show us a statutory provision.
Yes, ma'am.
Show us that the finding recorded in that item number 1 in that list is there is no statutory provision or a binding order. Show us either of that, then we will consider the matter. Show us either.
Before that, my lords, I may take my lords to the operative portions of the NGT order. The NGT order was not set aside.
No, we can't get into that exercise at all here. The NGT order, Honorable Supreme Court has remitted the matter. Upheld and remitted the matter insofar as, in fact, they don't even talk about interim or temporary compensation. Whatever payments according to our due, they said that the NGT decide. That's over. We have this order. Show us a statutory provision.
Section 20 of the NGT
Let's
Act.
look at not NGT Act.
The Air Act and Water Act.
Show us.
As such, I make this submission. Under the Water Act and Air Act, there is no such provision in compensation. However, what had happened before NGT, that is relevant. That is what I'm making a submission. A discussion had come up in those NGT orders.
Sir, what is the point? NGT order was there, went to the Supreme Court. Supreme Court had sent it back. Now, what are we even deliberating about?
That's my submission is that.
Now, how do we uphold this? On what basis do we uphold? Based on a discussion before the NGT.
That's based on the direction given by the NGT to the pollution
So
control boards.
that is superseded, merged, or modified, or whatever you call it, remanded, whatever words you want to use.
Respectfully, the order is not me.
You want us to interpret the Honorable Supreme Court's order and hold that the demand for interim compensation made by you was confirmed by the apex court. You want us to say that? That's what you want us to do, right?
That's my submission.
Right. So let's see whether we can do that. Let's see whether we can do that as per the Supreme Court's order. We come back to this. Isn't that right?
But if I may,
I want us to interpret paragraph 12F to hold that the directions issued by the NGT demanding interim compensation was confirmed by the apex court. That's what you want us to do.
It was confirmed by the apex court.
That's what you want us to do, right? Okay, whether we can do it or not, we'll have to see. It doesn't look like
It shall be open to the tribunal to pass such orders or interim directions calling upon the non-compliant unit to deposit such. It is not for us to decide. For the tribunal to
neither
decide.
did the Honorable Supreme Court decide that they have to pay.
That's what was called in question.
The tribunal may deem appropriate.
Hair splitting. I didn't want to say it, but
No,
what's the point?
I'm only making a submission. That's at most. What was called in question is that very direction given to the state pollution control boards to impose the compensation. That's on the point that can the NGT take any action based on suo motu paper article.
Yeah,
That's I may request my lords to give the judgment. The judgment is very clear on the fact that.
Sir, we have seen it.
That's my lords.
How much ever you read, reread, and try to interpret or construe or look at it, it's can't be changed. We can't change it.
That's the order of the NGT. That's my submission that was not set aside by virtue.
We understood that.
And
the direction issued permitting you to impose interim compensation has not been expressly reversed or set aside, and therefore that stands despite the Honorable Apex Court's order. That is the submission. We'll deal with it and say because of
decided by the tribunal.
Right. We'll note that submission. Or you want to file statement of objections and then the board, I don't know.
may I just make one submission? May I just make one submission? Yes, my lord. I only want to make one submission and then leave it to your lordships. Now, my lord, in this case, there is a Kannada Gade, my lord, proverb. It says, Yattitu andre kotke kattu anta. It means somebody just said that a bullock has given birth to a calf. So they said immediately take care of it. It's as absurd as that. Now, my lord, a bullock cannot yield a calf. In this case, my lord, they issued this order. After that, they issued me a closure order which they revoked and said your consent is valid. I produced that, my lord, at annexures, my lord, T, U, and V. 1 month after this order, which is impugned, they go into the whole thing and reiterate my consent order. Now, my submission is that, and no natural justice, not whatever my learned friend may argue.
We'll stay till the next date of hearing. Let them file their objections and then we'll.
Please.
If you want, otherwise we'll hear you and we'll pass orders right now.
We file a statement of objection.
All right. Pass a detailed order. Right.
Reasons they need.
Right. Third, Shri S.S. Naganand, learned senior counsel for the appellant, for the petitioner, and learned counsel for the respondents, and peruse the material on record. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned senior counsel points out that learned senior counsel submits that the issue involved in the present petition is directly covered by the earlier decision of this court in the case of Messrs. Paragon Polymers Products versus Karnataka State Pollution Control Board and another and connected matters in WP 5847 of 20 dated 16/3/2020, in order to point out that in the said batch of petitions, this court has held that the impugned demands for interim environmental compensation or for environmental compensation charges are without jurisdiction or authority of law, and that the same deserve and the same were accordingly quashed. Full stop. It is also submitted that though the National Green Tribunal wide order dated 23/8/2019, orders dated 23/8/2019 and 14/11/2019 issued several directions, including directing similarly placed petitioners, isn't it, to pay interim compensation, the said directions were modified, were set aside by the Apex Court in Civil Appeal 2218-2219 of 2020, dated 25/2/2022, by issuing the following, by directing the National Green Tribunal to pass orders or interim directions calling upon non-compliant units to deposit such sums inter alia for mitigating the environmental damage as the tribunal may deem appropriate. It is also submitted that the impugned notice, demand notice, is it? The impugned demand notice is violative of principles of natural justice, and the same deserves to be quashed on this ground also. Full stop. Shri Mahesh Chaudhary, learned counsel for the respondents, seeks time to file statement of objections, relist after 2 weeks from date. 13.4. Meanwhile, the operation of the impugned order, is it? The impugned order at Annexure A, dated 31/1/2020, issued by respondent number 1, is hereby stayed till next date of hearing. Statement of objections, if any, by next date of hearing.
Number 22.
22, I am appearing for respondent number 7 to 10 counsel. For on their behalf, I have already filed the counter also.
Illegal layout in a green belt.
And now this is the state has filed report. But ask for a report from respondent number 3 and 4 on the last occasion. They start time to present respondent number 4, DD. Notes 14/1/2000. Court has directed the BBA to secure instruction as to what action has been taken by the BBA for formation of illegal layout. My lords, I draw my lords.
14/1/22.
Please.
Then,
my lords, I secured the instruction, my lords. You have issued a notice to the my lords, that is Pragati residential layout. I was stating that why not the actions not be taken? The status report filed by the state court confirms all the grounds.
Legal layout, unauthorized layout. No. What do we do? Status report confirms that all those. Who appears for the developers of the layout?
Developer, my lord, I am appearing for developer.
And you appear for? Right. The developer is R7. You appear for? R11 and 12. Mr. Rajgopal, sir.
Yes, my lord.
Illegal layout.
My lord, they are saying so.
No, they have initiated action against you already.
But
Proceedings. Status report shows.
Proceedings are initiated.
Proceedings are initiated. You'll have to serve copies on.
I think, my lord, now notice have been served very recently. We called upon to file objections, my lord. We are yet to file objections before the authority.
Protection to the general public is concerned, actually.
As soon as the proceedings have been initiated.
We'll close the proceedings in view of the status report. Right.
All right, now they have taken cognizance. They have initiated the proceedings. We will direct them to finalize the proceedings in a time-bound manner. And because the purpose of this PIL was to just highlight this illegality that has been done, now they have taken cognizance, they have initiated proceedings. What for we will keep this pending? We will record that. Even you say that the road has also been.
Page 176. We'll record that also. In this petition, petitioner is sought for the following release. In this public interest litigation bracket PIL, petitioner is sought for directions, sought for the following reliefs. Full stop. The reliefs are in respect of the scheduled property known as Pragati residential layout, formed out of survey number 113/6, measuring 3 acres 26 guntas and 4 guntas Karab, situated at Vartur village, Vartur Hobli, Bangalore East Taluk, now coming within the jurisdiction and limits of BBMP, as described in the schedule to the petition. Full stop. Pursuant to directions issued by this court, status report has been filed. Status report dated 19/3/2022 has been filed by the state government, giving details of the proceedings already initiated
prior to the filing of the petition.
Initiated by the state against the respondents.
Number 7.
Respondent number 7. 7 and also 8 to 10 are.
8 to 10 are the partners of.
We'll say initiated in respect of the scheduled property.
11 and 12, my lord. Against 11.
Initiated in respect of the scheduled property. So the status report and the documents enclosed therewith are hereby placed on record. Full stop. The learned counsel for the petitioner submits that in addition to initiating action and taking steps by the state government again in relation to the scheduled property as seen from the status report, the respondents 7 to 11 have also, what have they done? They have also encroached upon a pathway in the scheduled property, in respect of which the respondents have to take necessary action also. Said submission of the learned counsel for the petitioner is placed on record in view of the aforesaid. Per contra, learned senior counsel for respondents 7 to 10, as well as learned senior counsel for respondents 11 to 12, dispute the various contentions urged in the petition and submit that they would contest the proceedings initiated by the state government in respect of the scheduled property. The said submission of learned senior counsel is also placed on record. Full stop. In view of the aforesaid facts and circumstances and the submissions made at the bar, as well as the status report filed on behalf of the state, we deem it just and appropriate to dispose of this petition, directing the state government to conclude the proceedings.
One submission. Tashildar has initiated the proceedings. He is not a party before the court.
say on
Competent
behalf of
authority.
the competent authorities to conclude the proceedings initiated in respect of the scheduled property, as well as address the grievances of the petitioner in respect of the pathway allegedly encroached upon by the respondent 7 to 11 in the scheduled property.
In a time bound manner within 6 months.
All right, 7 to 10. Within a period of 6 months from the date of receipt of a copy of this order. Full stop. All rival contentions are kept open. No opinion is expressed on the same. Subject to the aforesaid directions, petition stands disposed of.
We are very grateful.
Right.
Objections?
Serial number 23 and 23.1. We are contemplating to issue fresh show-cause notice, not the liberty. This may be.
It has to go then.
This has to go.
If you want the orders, we go and they can issue all contentions.
Will heard in this petition, petitioner is sought for the following reliefs. Kindly extract, full stop. Heard learned senior counsel for the petitioner and learned AGA for the respondents and peruse the material on record. Full stop. Learned AGA submits that the on instructions submits.
Fairly submits.
On instructions fairly submits that the respondents would be taking necessary steps to issue a fresh endorsement, is it? Fresh show cause notice and fresh endorsement.
Why you admit that this order is not sustainable?
That's what we'll have to.
Not without the amount was quantified, without providing an opportunity to the.
You will have to say fairly concedes.
Fairly concedes that in view of the fact that
the order has been passed
without opportunity, without affording any opportunity to the petitioner, thereby violating principles of natural justice, the impugned order is vitiated, the impugned notice is vitiated, and the impugned notice as well as the consequent endorsement are liable to be quashed.
Only notice. There are 2 notices.
Notice.
No endorsement.
What is this annexure H?
What is also not read.
Second.
Will not proceed to the first one. They issued one more.
Both are notice.
Both are notice only.
Notice.
Annexure. All right. Both are notices. E and H are liable to be quashed. Submission of learned AGA is placed on record. Full stop. In the result, we pass the following order. Petition is hereby allowed. The impugned notice at annexure E dated 1/7/21 and as well as the impugned notice at annexure H dated 9/8/21 are hereby quashed. Liberty is reserved in favor of the respondents to take appropriate steps in accordance with law after providing sufficient and reasonable opportunity to the petitioner.
23.1.
Same order. Annexures change agata. Will the annexure change?
Okay. The endorsements.
We'll caution. Same submission.
First one,
The first one it is F and K.
First one is E and H. The second one is
C from the period.
H and J. Sorry.
C from the period. Put the date.
We will do it, sir. We'll caution. He is considered.
Only 3. What is
24.
24. Mushayangar.
Is that petitioners, is that call for certain jobs which were put out
My lords, the adequate reservation for persons with disabilities was not provided. The impugned notification is at page 51.
What all has been done? What has?
Now, my lords, there was an interim. I'll just brief my lords. After when this matter was initially heard in 2012, there was an interim order of this honorable court that 3% of 2% of the post should not be filled up and should be kept vacant. My lords, that interim order is dated 26 July 2013. So they were permitted to fill up the posts, but not to fill up in the 19 posts that we were saying they had not reserved for persons with blindness and low vision. 2% of posts should be kept vacant. Thereafter, my lords, we filed, when this matter was heard, we filed a memo with all the posts identified. Government has also filed its reply. One submission I want to make. Did they keep this 2% of posts vacant? In fact, it was asked, what is the status now? Government has still not given the status that whether they had in these 20 posts, they had kept 2% vacant or not. And then on the merits, these posts are clearly identified. And my submission
Whether the rules have been framed.
Which rules are not required to be framed under the, my lords may just see the 95 Act or the 2016 Act.
Is there any percentage provided under the Act?
Yes. Under the 95 Act, it was 3% of posts. When this notification was in question, my lords can just see the section 32. There is a requirement under the central legislation.
Now the posts have been identified under the 2% reserved.
3% were reserved over.
No, as per the interim order, 2%.
Interim order dated
26th of July.
Order dated 26 July 2013.
That's right. 2%.
2% to be kept vacant and not to be filled up.
Now the posts have been identified under this 2% quota.
All. According to me, my lords, the posts are identified. 1 or 2 posts out of the 19 posts are not identified. Despite that, this reservation was not done. So now the limited question will be, if these posts have been identified, the law says they should have been reserved, then the persons with blindness and low vision, there should be a call for refilling those posts and they should be filled up.
You appear for?
I appear for the Public Service Commission, the respondent number 1.
Yeah.
Insofar as at the point they had initially challenged the recruitment notification that we had, which was at Annexure A, whereby we had notified around 31 posts. Out of that, their allegation was that in respect of 20 posts, we have not provided for reservation insofar as blind and low vision persons was concerned. Initially there was an interim order that we should not proceed with the recruitment. After we filed an application for vacating stay, since the court found that it was only 2% at best that they would be entitled for reservation, excluding that 2%, we were allowed to carry on with the recruitment. Interim order is there and it has been complied with. Now, as we have filed our statement of objections long back in 2013 itself. What had happened in respect to the 20 posts that my learned friend is canvassing about.
19. She's saying
19 posts. In the petition, it was 19 posts. In respect of those 19 posts, as on the date of the notification, only in respect of 3 posts, there was identification, for reservation by the state government, because that was a prerequisite at that point in time. And in respect of those 3 posts, we had not provided for reservation because the roster points were not reached as per the government order. We have stated so in the notification. We have stated so in our objections. So there, insofar as the remaining posts are concerned, it was only by virtue of a subsequent notification that some posts have been identified. In respect of the remaining posts, there is no identification. Those subsequent notifications are prospective in nature. And in respect of whenever the roster point reach, all those vacancies will be available to a physically handicapped candidate. There is no dispute about that. Now, this petition technically has become infructuous in as much as subsequent identification has happened, which is prospective. And in so far as the 3 posts which were identified as on that day, the roster points had not reached. which we had stated in the statement of objections. And they will have, and they have filed a memo, my lords.
19 posts. Affidavit is there. So you have to respond to that.
Take the response.
And in respect of the 3 disputed posts where there was.
You are going to stick with this identification of these 19 posts, and you will continue to treat them to be reserved for blind persons as per the order of the court. For the future, if we dispose of, we'll record your statement, dispose of.
Please, milords, insofar as the 3 posts which were identified, which were not provided for, 2 milords posts were withdrawn subsequently, so that issue will not arise. In respect of the remaining posts where there is a subsequent identification, it was prospective, and milords, whichever roster points will be available, it will, the state has to, milords, because the roster points are released by the states. We are just a recruiting authority.
We are only concerned that whether you will be providing the reservation for the blind people in the future recruitment or not.
It has been provided in future also, it will be provided, and during the pendency of the case also it has been provided by virtue of these identifications.
That was provided because of the interim order granted by the court.
No, it's not with different notification, not this notification. In respect of different notifications that were notified after this petition was filed, milords, in view of.
Yes, what do you say?
Yes, no, my lords. My one submission is, my lords. Lords may just for a moment see a memo that I have filed dated 27/9/2021.
This must be one of the oldest cases.
Yes, my lord, and it is really unfortunate. 27/9/21.
You may have to respond to the affidavit dated 10.
I have seen that affidavit. I will respond.
Right. In writing, if you respond, then we can look at everything and then we'll pass it.
I will respond in writing also, but my.
Do you accept this affidavit?
I've got the affidavit, but the response I will give my lords. My lord may just see for a moment.
No, for each post, each serial number, they have said something.
I have in fact given.
No, if you accept this, what they have said in relation.
I'm not accepting it for a specific reason.
You'll have
what
to,
they are.
You'll have to say that in writing.
I will say that.
Put together and pass an order.
I will say that, but may I just for a moment just show my lords my memo. Just my lords will kindly see 27/9/2021 memo, where I have made a list of the various 19 posts. Now, in these posts, the argument of my learned friend is some were identified, only 3 were identified officers, others were identified subsequently. My lords, that is with great respect wrong. I have put all the dates of notification except 3 or 4. My lords may see all were identified in 2006, 7, 9. So then once they are identified, there is no excuse they have for not reserving. And the second issue is some are
in your
identified.
memo.
We cannot identify the post.
Yes, of course not. The government
In
has
your
not.
memo,
Yes.
1, 2, 3, 4, 5, 6,
My lords, 2
7, 8,
Yes.
9,
are all
10,
identified
10 have been identified prior to.
prior.
Right.
Yes.
Then 4 have been identified in 2016.
Yes, some are identified later.
Remaining are not even identified.
Now, my lord, on the
This you have said. In response to this, the state government has filed a detailed affidavit in relation to each post,
Yes.
each
Now,
serial number. So you respond to their affidavit.
I will
And then
respond,
we'll-
my lord. I will respond.
You want us to dispose of today?
I can take a short leave.
Is it possible to dispose of without your response?
My humble submission is my lords have the time and are able to hear it. It will be there. It can be disposed. My lord, there is a decision of the Honorable Supreme Court. But my lords want me to.
No, you want us to decide which post is to be reserved, which is not to be reserved.
My humble submission is that it's only saying the excuse made by the respondent is that some posts were identified, some were identified much later. On the issue of those that were identified, they have to follow the law and they ought to have given the reservation, which they didn't. On the posts that were not identified by country, that were identified subsequently, there's a decision of the Honorable Supreme Court that I like to pass. The Honorable Supreme Court held that if the government
Madam, that's what.
identify,
See, each post, including
I will respond.
unidentified, identified,
Let me
subsequently identified, they have given details.
I'll
Why don't you
respond to their
respond?
act. I'll do that. Kindly give me 2 minutes time. I'll respond.
Isn't it, sir?
How we will decide about it?
we won't decide about identification. We will not identify.
Then
Ultimately,
Whatever is said. Then we'll have to close it.
government
Sir,
cannot
then
take
we'll have to simply close it.
hide behind its inaction.
they agree to make the writ petition's purpose was to provide the reservation. only.
Correct.
Now
That's-
that has been.
We'll close it.
I think.
I'll respond to each of their.
No, my lord is saying that the purpose of this writ petition has already been rendered infructuous.
My lords are in fact to some extent right, unfortunately, if it is passed. They were to keep aside some.
Now, when the writ petition was filed, the reservation was not provided.
Yes, reservation was.
Now, in view of the interim order, the state government has agreed to provide the reservation, and they have now subsequently the posts have been identified. Everything has been done. Now, by subsequent notification, they are ready to give this reservation continuously, and the posts have been identified for that. Now, that was the purpose which has been done. Now you want us that which post is rightly reserved, which post is not rightly reserved. That was not the purpose of the writ petition, and that is not required to be done by us.
Great respect, my lords. I'll just there was an interim order that some posts were to be kept unfilled and vacant 2% and should not have been filled up. If those posts have not been filled up and kept vacant, those posts should be there, which should be filled up. Second issue is where reservation is not provided, my lords. The rule is that if it was a lapse on the part of the government, even supernumerary posts can be provided. On that, I leave it to my
file a
lords.
counter to this
I'll file a
affidavit, then we'll take
file.
it.
At least they can give the list of the vacancies they have kept as per the interim order, or have they filled up? If they have 2% posts left vacant.
It's a PIL. Earlier, my lords, there was no identification by the state government. The same petitioner, my lords, had come up before this court, and there was identification by the state government.
That is not required.
They cannot say supernumerary post means that means somebody might be behind it.
At least the vacancies, they can give a list, what vacancies they have kept as per the interim order. My lord, at least even if those few posts, if not more, can be filled up. Ultimately, it is about persons with blindness and low vision as per law. It is not that they're doing anybody a charity.
At request of learned, it is submitted on by learned senior counsel for the petitioner that the petitioner would file a counter affidavit to the affidavit dated 10/2/2022 filed by on behalf of the state government. Released April on date.
22/4.
Serial number 25, Lord, I beg to appear for the petitioners. Lordships, I pray for a short accommodation to seek instructions from my client to withdraw this writ petition. My humble request is that your Lordships may kindly grant me a few days.
I cannot have any objection for withdrawal, only one submission, Lord. Lord, the second petitioner, Lord, was Lord the president of an association, Lord, called Gokarna Hitanakshana.
They're not closing the case.
Very good.
They want time to get instructions and close.
So then this honorable court, Lord, had passed an order imposing fine because Lord of threats, etc. Anyway, Lord, I will just Lord, point it out on the next. Great.
14/6.
I'm grateful.
Number 26. RG Kulle.
Please, my lords. I am before my lords. And an application is moved amending the cause title because the original petitioner managing director expired. Pursuant to order passed by my lords on an earlier occasion, I have filed the IA, fresh IA, and along with the death certificate also, my lords.
Application. Some application to bring on record the new managing director of the company.
Yes, my lords.
He says, but it's not there.
I have produced along with IA number 1 of 22, my lords. I have
realist date kodi. real estate on so and so, registry to put up IA number 1 of 22, is it?
Please, my lord.
IA
On
number 1 of
I have produced.
by the next date of hearing.
Please, my lord.
13-4.
Please, my lord.
Number 27. Okay.
Yeah. I applied for the second respondent. I had filed the power in the last occasion. And the statement of objections also have been filed. My name is not shown in the call list.
Shri Badrinath, Learned Counsel, submits that he has entered appearance on behalf of respondent number 2, registry to print the name of Learned Counsel, statement of objections to be filed by next date of hearing.
Filed?
Already filed.
Already filed.
The direction to
Submits that entered appearance and filed statement of objections. Full stop. Registry to print the name of Learned Counsel and relist on
Any date next.
Lord, there's a direction to complete it within about 2 months, page 68 by the FX court. The review petition filed for
urgency.
order passed by the
Urgency, yeah. Is there urgency?
Urgency, but there's a time fixed by the FX court. I only wanted to bring your lordship's notice, that's all. Page 68.
Page?
Page 68. 7 is the order. 68 will not be filed. Last but one paragraph.
Page 68. Review application to be disposed of within 2 months. Next Monday.
This PIN. Not a kindly direct the district to not put up the original file.
Give it Monday.
Next Monday. Registry to put up the paper records of
Petition law.
writ petition number
0850-2025.
He says, no, his name has not been shown.
That I have directed. Registry to print the name. Registry to put up the records of WP 1227 of 79 of 21 clubbed with WP 12028 of 21 by the next date of hearing.
Rule number, not page 29, 10850 of 21.
Oh, sorry. WP 10850 of 21 by the next date of hearing.
Okay. Applications number 28.
Student counter suit was decreed by the trial court. Counterclaim was rejected.
Give it. Heard IA 1 of 2022. Heard on IA 1 of 2022. Give a date.
19-4.
Just hold on.
May I request one thing? So, Lordship, permit me, I will take one submission.
Yes.
Matter, of course, the voluminous records are there. I am not disputing that. But what happened was at the time of admission, there is a suit for money decree. I have been directed to pay the actual amount plus 6% interest. That works out to about 3 crore rupees. We have deposited 1 crore 75 lakhs. In the meanwhile, my husband of the petitioner, he has, because of the COVID, he fell ill. Now, Marat is suffering from serious Parkinson's disease. I am ready to deposit 1 crore 75 lakhs rupees, remaining amount.
We have fixed the date. Next.
Number 29. Somshekhar KM.
$28.1.
Same order. Same.
Posting. Same order in
Same.
28.1. 29.
29. Somshekhar KM. Senior is not
IA for posting is there. IA for posting, you want to argue? Yes. Date April 9, last. IA 1 of 22. This was same month.
I am for the petitions, man.
For respondent number 3, my lord, there is one aspect I'd like to point out. If my lords were to kindly see the order sheet, this matter has been repeatedly listed, my lords, to appear on my IA for vacating stay. My lords may recollect, I made some submissions that there is a park in the city of Belgaum. The Belgaum Smart City wants to redo the
early hearing. Early hearing you want.
One aspect, if my lords permits, I'd like to point out. If my lords were to see the order sheet, the petitioner has repeatedly failed to comply with office objections. In fact, on the 14th of December, my lords posted the matter on 15th of February. It came up before the registrar, my lords. Now, on one hand, there's an interim order in their favor. They refuse to comply with the office objections. Now, my lords, the difficulty.
All right, we'll fix a date, then we'll continue.
The earliest, if I could request.
No, I have complied with all the objections, my lord. I had paid
hearing filed by R3 or list on.
Not 8 minutes. Our money, Millards, is
All
being
the
lapsed.
funds are held up.
Held
The
up,
funds
Millards,
may
and
lapse.
development work is stopped. Development work is stopped, Millards, Smart City.
All right, we'll give it.
Please. Short.
12-4.
This is not affected on R4 and 5 in this matter.
4 and 3.
अभी देखेंगे when the matter is listed only then.
Otherwise, registry, that is happening.
Before the court. List on is not before the court.
31.
Respondent.
There is a deposit of 26 crores before the commercial court. The other side has filed an application for withdrawal of land. Therefore, my lord, I have made an application. Further, not the appellant, my lord, is BSNL. It's a public sector.
Heard on IA4 of 2022. Just already date is there.
Deposited. It has been deposited before the commercial.
All right, date is there. Your IA is for
I file
post.
my objections to the IA number 3, my lord.
Withdrawal of that.
Same application can be filed before the executing court, and the executing court can deal with those applications.
Based on date fix.
It's now posted on 30th from today. I file my objections to IA number 3, if lordship permits me.
If you want any further interim relief, then you will have to move an application. Don't have to tell you.
But I have moved an application for direction to the commercial court.
They come before the court.
Not there, the matter is posted on 30th. Today it was posted. Now
It's on the execution. Execution. They want to withdraw the amount from the commercial. Deposited here, is it? Deposited there.
At the time of granting.
Dispute is regarding quantum or the entire amount, liability.
our contention.
How can you withdraw?
When the 34 petition was filed,
Right.
say was granted subject to deposit of
All right.
50%. They deposited 50%.
Right.
Now 34 has been dismissed.
Right.
And they are in 37.
Right.
They have filed an application seeking for stay.
Right.
Which I have filed my objections and have
Right.
shown, even as per memo of calculation, they are required to deposit another 50 crores.
No, but if you
I will,
withdraw,
I,
if you
I
withdraw
will
there.
withdraw it subject to giving due security to the court, subject to the satisfaction of the executing
No,
court.
What security?
Sorry, my lord.
What security? What security?
With regard to the
Bank
bank
guarantee.
guarantee or a
Bank
fixed, I will adequately secure them, my lord. That's a matter for the executing court.
No, it's not a question of matter for the when matter is seized by this court, when the section 34 order or the arbitral award is seized by this court, there is a question of leaving it to the executing court.
I make a
We'll have to make some arrangement here, no?
May I make a submission.
Right.
IA number 1 has been filed, which has to be considered, my lord.
Right.
Lordships are aware that although they are BSNL, no concession can be shown in view of the.
So they have deposited.
No, my lord, the
Then
balance 50 has to be deposited.
That's right. No, arbitral award was challenged. They deposited 50%. 34 is dismissed. 38, 37 is pending before us. Now, if you were to withdraw that 37, that 50%, if you were to withdraw it, then what happens?
And upon furnishing the.
So you do it here itself. Do it here itself. You furnish bank guarantee, we'll permit you to withdraw there.
In fact, it is in deposit.
Date fixed है ना already लगा हुआ है.
No, but they are pressing the execution. And everything. On the other hand, don't precipitate the execution proceedings. I mean, why you're trying to push there and then you are trying to push there. They are pushing the case here.
Two submissions.
Right.
One is insofar as 37 is concerned. My request is let them deposit 100% because it is to be treated as a money decree.
Right.
Principles of Order 41 Rule 5 applies.
So that is discretion for us, right? Have we passed an order? Order sheet, have we passed an order? So instead of that, we'll decide the main appeal. That's the application is filed.
Lord, in similar matters.
Expedite the hearing.
We'll expedite the hearing. We'll hear the main matter. Till then, don't precipitate the.
नहीं अभी कुछ नहीं till then.
Till then.
नहीं अभी नहीं brother.
That's right.
It's an application only. How can we pass hearing?
Correct.
We can only say to expedite the hearing.
We'll fix an earlier date.
Lord, may I make the request? I will not make any application for withdrawal, but can there be a direction to them to deposit the 100%? Because I have produced the financial statements of BSNL.
We are not hearing the matter. You people are arguing as if the matter is listed before us. It is only an application for early posting, early hearing, or an application for direction. We can fix an early date. We can expedite the hearing. Matter is already listed on 22nd of April.
Accepting the reasons stated in the application, IA number 4 of 22 is allowed. A relist for final hearing, relist on so and so, with the understanding matter would be taken up for final disposal on that day. Date April 1st. 7/4. We can't pass any further orders. It's only on the IA 4 of 22. That's the procedure.
Number 32, Raghu HP.
Date is fixed. 30th March it is fixed.
Date is fixed, madam. 30th March already. Right? That's what it will be taken up on that day. Since the matter is already listed on 30th March, IA number 2 of 22 does not survive consideration.
Let the name of Shri P. Prasanna Kumar Milach may be reflected.
Registry to print the name of Shri P. Prasanna Kumar for
R1.
Respondent number 1. Pass over.
Pass over matter. Seal number 11. Shiv Kumar.
The respondent was not there. We wanted to refer it to mediation. Small amount. Only interest dispute.
D. Hanumantarayappa, Caveat respondent.
लगा दो next week or
date.
Case list is being revised. Counsel for Kavita is not present. Relist.
31-3.